Good evening. This side Rahul Magan is a Group Chief Executive Officer, Treasury Consulting, and also a venture capitalist of a profitable company. So I have changed my introduction because after watching Byju's, Ola, Uber, Swiggy, Zomato, Delivery, Paytm, and many such companies, I finally realized that without having a single dollar in my balance sheet by any private equity or any venture capitalist, we are 100% profitable since inception. So why don't mention this? Because if these loss-making companies, Byju's, Ola, Uber, Swiggy, Zomato, and what all, if they claim to be a unicorn, then we are 100% profitable. As we speak, Treasury Consulting is a hedge fund, but it is proprietary, which means we trade our own capital. We do not take third-party capital. With due respect, like US hedge funds, we trade in FICC, which is fixed income, currency, and commodities. We trade in equities and crypto also. But like I said, it's a proprietary hedge fund. So there is no third-party money which we are taking into consideration. That is the most important thing for us. Apart from that, we have our own private equity fund, whereby funding is done completely by Treasury Consulting. So like whatever profit we are earning, we substantiate a part of the profit to our private equity fund. If we find any good startup, we invest. If we don't find, we invest this money in the mutual funds. As simple as that. Because nowadays finding a good startup is really very tough, to be honest. Apart from that, we own our paid news desk, our learnings platform, our Sheetal Academy, our trainings, our TRFX Academy, our private placement program, and many more consultancy services. In case you wish to have any information, you can definitely WhatsApp on my personal number, which is +91 9899 242 978. Alternatively, you can WhatsApp on my back office, which is +91 9818 485 155. Today, I would like to thank you, the God, because God is really very kind that, God has given us an immense functional skills, whether it is financial market, credit market, derivatives, even exotic derivatives. And since inception of our YouTube channel, Treasury Consulting hardly left anyone in terms of challenge. Now, whether it is international banks like Goldman Sachs, JP Morgan, Citi, my loving Big Fours, EY, KPMG, Deloitte, PwC, corporate, SoftBank, governments, Reserve Bank of India, or any regulator. But unfortunate part is that none of the challenges is accepted as yet. None of the challenges is accepted. And now we're going to be using our functional knowledge in the law sector. And I'm assuring you that with the immense blessings of the Lord, we would be putting up the knowledge in the law which is not there on the YouTube. Because we would be adding the flavor of functional knowledge. And today I'm bringing yet another thing for you, which is Section 6 of Insolvency and Bankruptcy Code, which is known as CIRP, Corporate Insolvency Resolution Process. Throughout the video, I will not mention the complete, I will mention corporate insolvency resolution, short. And I would like to integrate this with Section 23 of the Indian Arbitration and Conciliation Act. I think these two are, you call this brother or sisters. That's up to you, but they both are brother and sisters. Although there are many sections of Indian Arbitration Act, so I will not mention complete Indian Arbitration and Conciliation Act in the complete video. I simply mention Indian Arbitration Act. So there are many sections of Indian Arbitration Act which conciliate Conciliate in English means hand in hand with insolvency and bankruptcy code. But unfortunately, people have no knowledge, so they never put this in the public domain, but we are here. So guys, section 6 of insolvency and bankruptcy, IBC, talking about CIRP, which is corporate insolvency resolution process. Now, what the hell is that? First of all, let me give the theoretical definition, then I give the practical definition. As per section 6 of code, following may initiate CIRP if a corporate debtor commits a default. Now, a financial creditor, an operational creditor, and the corporate debtor himself. Oh my God, very heavy terms. Financial creditor, operational creditor, and corporate debtor itself. But like I said, we are different. We're not going to be copy paste. When the revised code of insolvency and bankruptcy proceeding came in public domain, when I was evaluating this, I noticed a flip side, which I mentioned to the government officials long ago in 2016, but as usual, it was ignored, which is the critical party in financial creditor example. So I am going to be covering an example, my favorite example, Ramlal Chole Bhature. Now, if by chance, every time I speak, this company exists and the examples which I'm putting, and seriously, this example exists and it is purely coincidence, because I always have an example on Ramlal Chole Bhature, so that, I've never seen such company, that is why. So if by chance it exists, it's a coincidence. So no intentful, please. So let's take an example. Ramlal Chole Bhature is having two proprietors, Ramlal and Shamlal, both brothers. Okay. Their father, Sundarlal, started a business of Chole Bhature, and now he is old. He cannot take up the business, but he said to his both boys that, guys, you take up, I do the supervisory job. Okay. Both brothers agree. So Sundarlal ji, the founder of Ramlal Chole Bhature, Sundarlal ji, both sister Ramlal and Shamlal, take up the business. Eventually, both agreed that they are not going to be listed. So note carefully. The founder, Sundarlal ji, who started the company, he decided not to be listed. His both son, Ramlal and Shamlal, would continue with the same proceedings, that we are not going to be listing. So we're going to be an unlisted company. Perfect. But they wanted to expand their business, Chole Bhature business. So let's take an example that Sundarlal ji started from Mumbai. Now they wanted to take up to Delhi, Calcutta, Chennai, all the big cities. Okay, for that they need funding. They got up a funding from any venture capitalist and private equity firm. Say, I'm again creating a hypothetical example, Blackstone. It's a hypothetical example, Blackstone. Now, every year, whether you are a listed company or an unlisted company, you need to do the audit and you need to file the tax return. That's a fact. This company do the audit and they file the tax returns. Okay. But eventually, since they need the funding, they took some debt from the bank and debt from the market in the form of non-convertible debentures. So the private equity firm Blackstone told them, we are funding you something, but your expansion is bigger than our envisaged, so it would be good if you raise some money from the market. They decided to go ahead with NCD, non-convertible debentures. So before I proceed further, let me remind, Sundarlal ji started a company, Ramlal Chole Bhature. Now he is old and he wanted to shift from operational responsibility to supervisory responsibility. He handed over the company to his both son, Ramlal and Shamlal. Now, Sundarlalji used to take care of business in Mumbai, but his both sons wanted to expand to Delhi, Chennai, Calcutta, and different parts of India, big cities. For that, they need funding. They got a venture capitalist or a private equity, Blackstone. Eventually, Blackstone suggested them to raise NCD, non-convertible debentures. For that, they approached a credit rating company. And I'm not naming any credit rating company, you name whatever. Now, this credit rating company give them credit rating AA plus. This is the key point in the financial creditor. Before I go further, let me have a theoretical definition of the financial creditor, and I always have an issue in that regard. Section 5, subsection 7. Section 5, subsection 7 of the code defines financial creditor as a person to whom a financial debt is owed, and includes a person to whom debt has been largely assigned or transferred. In other words, financial creditor refers to lenders who have provided any sort of credit facility or a loan. Did you notice that in this latest amendment of Insolvency and Bankruptcy Code, what was the definition of the debt? Because debt are of three types. Number one, the working capital funding. Number two, trade finance instrument. Number three, venture capitalist and private equity. I repeat, number one, the working capital funding. Number two, the trade finance instrument, SPLC, BG, SPG, DPLC, subordinate bonds, and many. And third, private equity and venture capitalist, which means equity dilution. But now there is a two parts of this. Number one, private equity with equity dilution, private equity without equity dilution. So the first and the biggest mistake of section 6 of Insolvency and Bankruptcy Code is the definition of the debt is incorrect. Alternatively speaking, the definition of the debt is 1957 definition, but the word is 2022. Because in this only hardcore definition is there, which is the working capital funding. Where is trade finance instrument? Where is private equity? Where is venture capitalist? Where is venture capitalist debt? And where are convertibles? That's very important. So note that Ramlal Chole Bhature decided to take up a funding. So the funding means debt. Now that debt having multiple sources. Section 6 of Insolvency and Bankruptcy Code do not talk about this, which in English or a lexical word means flip side. Now what the hell is flip side? Flip side means weakness of the law, which is quite a lot exposed. You got my point? That's very important point. So I repeat, section 5 subsection 7 of the code defines a financial creditor as a person to whom financial debt underlying is owned and include a person to whom such debt has been largely assigned or transferred. In other words, financial creditor refers to lenders who have provided any sort of credit facility or a loan such as. That needs to be corrected. We are here, don't worry. Now, you know how auditors works in India. If you open Google and simply type audit scandals in India, the list is very long. There are humongous audit scandals in India, and leading are big fours, and many scandals are going even today. So there is no doubt that scandals are not going. They are going at a rampant pace. We know that how auditors audit the books of the companies. Now, when I say financial creditor, Why I am not including the auditor who not audited the book appropriately? Isn't he is a financial creditor? Reason being, whenever a company takes a funding, that funding needs to be verified by the auditor. The valuation of the funding needs to be done because many times the funding is done in the foreign currency. And apart from that, the auditor responsibility is to let investors know whether the company is a going concern or not. Because if the company is not a going concern, the lenders can immediately act it towards the borrower and say, guys, give our money back. And there are ample of evidences we have when in India and worldwide auditors not played their responsibility, especially the big fours. So this is the first catch of insolvency and bankruptcy code. Number two, I would like to bring a judgment by NCLT Mumbai. NCLT means National Company Law Tribunal. With request and due respect, there is an issue with that judgment. Now, Urban Infrastructure Trustee Limited versus Neelkant Township and Constructions Private Limited. NCLT Mumbai, CP number 221 oblique INB NCLT MB and whatever number. Order dated 1st March 2017. Corporate debtor raised an objection that since arbitration proceedings have started as per section 21 of the Indian Arbitration Act, these proceedings are non-maintainable. Corporate debtor. It was held that as per section 63, 231 and 238 of the provisions of the code, it will prevail the other proceedings. Pending dispute is irrelevant in case of application under section 7 of the code. Now, what is that? Now, first of all, let's go to the section 23, section 21 of the Indian Arbitration Act. I know what is section 21 of the Indian Arbitration Act, but I am reading only for you because I would like to give you, I would like to link two sections. Now, section 21 means commencement of the arbitral proceedings unless otherwise agreed by the parties, Ramlal Chole Bhature and the lender. The arbitral proceeding in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. So, the story is Ramlal and Shamlal, both son of Sundarlal, they are smart enough. They bought auditors. The right word. And what exactly they did, they manipulated the books. Now, the section 6 of the insolvency code do not mention the name of auditor, but I feel that auditor can easily be dragged in this case because it happens because of his wrong audit. Else, the lender could have asked to take the money much earlier than the anticipated. Example, infrastructure leasing and financial services, Diwan Housing, Yes Bank, PMC Bank. List is very, very long. And our so-called unicorns. Now the question is, in arbitral proceedings, when we speak about arbitral proceeding and we link section 21 of the arbitral proceeding with the section 6 of the insolvency code, then I feel that if section 21 of the arbitral proceeding is invoked, then there is no need for section 6 of the IBC until otherwise the arbitral tribunal is allowing both the parties to have separate litigation apart from Section 21 and Section 23 of the Indian Arbitration Act. So what the hell is that? Example. Ramlal Chole issued 5,000 crores worth non-convertible debentures. 5,000 crores, and auditor mismanaged the books at the end of 3 years. Oops. And now Ramlal Chole wants this matter to be settled via arbitration, and what they are saying, we are ready to pay 30%, 5,000 crore into 30%, which is 1,500 crores, and we are ready to pay the rest 1,500 crores as an equity participation in our company. Because now Ramlal Chole is in Mumbai, is in Delhi, is in Calcutta, is in Chennai, multiple cities, a brand. That is a separate thing, defaulted brand. Now, the question is, Ramlal Chole is agreed to give 1,500 crores, which is 30%, and rest 30% as the equity participation in the company. But as far as the Insolvency and Bankruptcy Code is concerned, I hardly see there is a provision of equity participation in CIRP. Number one issue. Number two, Ramlal Chole agreed to give 1,500 crore upfront back to lenders, which is 30%, and rest 40% they are ready to give SBLC, which is standby letter of credit. And I'm just getting a hypothetical example, they had a word with JP Morgan Chase Mumbai, the leading foreign bank of the world, and JP Morgan Chase have some conditions on which Ramlal Chole agreed, and they're ready to give 40% of 5,000 crore, which is 2,000 crores worth SPLC. In the Section 6 of Insolvency and Bankruptcy Code, this is not mentioned. Henceforth, the arbitral proceeding is required. So what I wanted to convey to conclude the discussion is that we have two sections of two different codes. Number one, Section 6 of the Insolvency and Bankruptcy Code, which talk about CIRP, Corporate Insolvency Resolution Process. This do not speaks the holistic definition of the debt. Holistic means 2022 definition of the debt, not 1957 definition of the debt. Number three, there are many instances like the example which I created of Ramlal Chole. In this, we can easily note that there is a need of arbitral proceedings. Henceforth, I repeat the judgment again. Urban Infrastructure Trustee Limited versus Neelkant Township and Constructions Private Limited. NCLT Mumbai, National Company Law Tribunal Mumbai, CP number whatever. Order dated 1st March 2017, corporate debtor raised an objection that since arbitration proceedings have started as per Section 21 of the Arbitration Act, these proceedings are non-maintainable. It was held that as per Section 63, 231 and 238 of the provisions of the Code, it will prevail over other proceedings. Pending dispute is irrelevant in the case of under Section 7 of the Code. Here I disagree with respect to everybody, because there are many cases in the corporate debtor, basically the financial creditor, which are beyond the scope of Insolvency and Bankruptcy Code, where an expert opinion is required. And I think in this case, the arbitration is required. And when the arbitration is going on, then it would be useful to uphold the proceedings which are either in NCLT or NCLAT. By the way, NCLAT will come if NCLT people are not happy with the NCLT, and then the Supreme Court. This is our understanding. So there are still many flip sides we have in Insolvency and Bankruptcy Code. There are issues with in Arbitration and Conciliation Act 1996 also. Every day we bring you something new about it. Treasury Consulting enters the law. The law of fraternity needs to understand the functional capability of treasury consulting is beyond imagination. Very soon we bring something which no one ever thought of. This is Rahul Bhagan from Treasury Consulting Group. You know my personal number, which is +91 9899242978. Have a great time ahead, sir. Thank you.